Okay. Good morning, everybody. Basically, I'm what we call, I think, the bridge speaker today. So I'm supposed to provide the connective tissue between Deborah's presentation and what Khaled will speak to you about after the break. And what I am going to do, and you'll see here's the outline, and I've set this up, sort of imagine it as building blocks. So during the course of, I think it's around 75 minutes, we will actually build from the initial concepts I touch on to the end. And then when we get to the end, hopefully that will have provided the foundation for the linkage to what Khaled's going to talk about. So overall, what I hope to do is provide you with a picture of the legal framework that regulates the use and disclosure of health information in Canada. So before I start, how many of you are lawyers? All right, that's okay. You can identify yourself. And I realize that most of you are not. So one of my key objectives is to ensure that I've explained everything in a way that makes sense to everybody else who's not sitting there reading 10 pages of legislation. So the way I attempt to do that is to provide examples of things as I go along. The other thing to note is certainly, as we've all experienced, the laws in Canada vary across the country. So I'm really going to focus on PHIPA, the legislation regulating health information in Canada. So I'm not going to get into all the differences across the country, but I'll use some other examples from other legislation as well. So what I propose to do is start with a discussion of terminology. And from my perspective, when I talk to people about any privacy issues, I found that sometimes we're not all on the same page with respect to the terminology and what it means. So I think that's really important. So we'll start there. And then I'm going to spend some time on the definition. While it is a term, it's one that deserves more attention, on identifiability. I'm going to pick up on Deborah's comments with respect to some of the key privacy principles when we're talking about this. Review some of the more common secondary uses in legislation. Then we're going to move on and use that sort of base information that we've discussed to look at some data flow scenarios and taking a particular example of disclosure for public health purposes. I'll speak to some risk mitigation techniques and then wind up with some conclusionary comments that, as I said, I hope will lead us into Khaled's presentation. If you've got any comments along the way or questions, please feel free to ask as we take this journey together. So I know for those of you that are either lawyers or worked in the privacy area for a long time, these general comments are probably really basic. But I want to review them today because particularly with respect to privacy and confidentiality, I find that sometimes people don't make the distinction. Privacy is the right of an individual to control the information related to them. And you see this come up when we speak about consent. Basically, that's an action on the part of an individual in which they exercise control over their information. Confidentiality, on the other hand, is an obligation of a recipient of information not to disclose the information provided to them in confidence. So as an example, all healthcare professionals for years and years and years have had ethical obligations not to disclose patient information. Okay, so in their codes of conduct, and that's a confidentiality issue. But when legislation dealing with health information privacy has come into effect, there are privacy obligations that are effectively new with respect to personal health information and go beyond those confidentiality responsibilities that healthcare professionals had as professionals in their practice. In security, we're talking about different types of measures that are designed to protect information against unauthorized use, disclosure, access, loss, and modification. And I put security in here just to draw attention at this time to the fact that there is an obligation to protect data against modification. And we'll see this as, I'll pick up this theme as we go through. Obviously, other key terms are related to information. Now, when I set up the next sets of terms that I want to review at the moment, I sort of had some challenges thinking about, well, what's the best way to do it? Shall I go through it alphabetically or sort of by concept? And I thought, well, it makes more sense, at least given the way my mind thinks, to look at them group by topic, because when we go through some data flows and sort of the questions that you need to ask yourself in any scenario, the questions relate to the information, the players, what's happening with the information, and that kind of thing. So I decided to deal with the definitions that way. So here we have personal information, which is identifying or identifiable information about an individual, and PHI, personal health information, that type of information relating to an individual's physical or mental health, etc., including an individual's health number. Now, legislation has a more expansive definition of PHI, but this is sort of the high-level definition. But what I want to note here is that in order for information to be either PI or PHI, it must be, as Deborah noted, identifying or identifiable. Otherwise, if it's de-identified or if it's aggregate, you're outside the parameters of the provision of the legislation. So obviously, whether or not information does identify an individual is a critical assessment. So we'll park that, come back to it later. So we've spoken about the type of information we're looking at, and now let's look at what I call the health system actors. So we have what are called in Ontario and some of the eastern provinces, health information custodians, or HICs for short, or for whatever reason, and I'm not sure, the Western legislation calls these individuals or organizations trustees. And these are entities, persons or organizations that have custody or control of PHI as a result of or in connection with performing their powers and their duties. And we also have what are called agents, not legal agents, but what are defined actors, defined in the legislation, of persons or organizations that with the authorization of the HIC, the custodian, acts for and on behalf of the HIC in respect of PHI, for the purposes of the HIC and not the agent's own purposes. So, and it doesn't matter whether the agent is employed by a custodian or whether they're being paid for it. And this is really, really important when you're looking at data flows. And let's take the example of a hospital situation. So in PHIPAA, custodians are enumerated. That means there's a whole list of them, and hospitals are one of the lists. Now, a physician practicing in that hospital as a healthcare professional is also an enumerated HIC on that list. But for some purposes, acting and providing services to hospital patients, the physician may be acting as the hospital's agent. But they're also a health information custodian in their own right. Okay, so that's an important point to keep in mind. And then the other actor here is what we've called a recipient. And that again is a defined term. Well, it's not defined, but the term is used in a particular portion of PHIPAA. And these are entities that receive PHI from a HIC that aren't a HIC. So for example, insurance companies, okay? They may receive personal health information from a physician, but insurance companies are not HICs. They're not subject to PHIPAA. They're subject to other privacy legislation, but they don't fall within this scheme. So now we've got information, the actors, and we're going to look at the information flows. So a collection, this is kind of self-evident, but one thing that's kind of interesting here is if you receive PHI, even though you haven't gone out and actively sought it, that's a collection. Use is the handling and dealing by a HIC of PHI in its custody or control. And a disclosure is making PHI available or releasing it by a HIC to another HIC or somebody else. And the note here is really important because when a HIC provides access to PHI to its agent, okay, that's considered to be a use by the agent, a use in that framework, and it's not a disclosure by the HIC or a collection by the agent. So as an example, say you have a hospital IT system and you have some systems people working on it, and in the course of doing their work for testing purposes or QA purposes on the system, it may be that they need to make sure that it's operating and they have to see an actual record. I mean, sometimes they won't need to see real patient data, but assume in this case there is a need to do that. In that case, the IT company is acting as an agent on the part of the hospital for fulfilling this function. They're limited to using that PHI for the hospital's purposes, i.e. providing services for their IT system. So the IT folks are considered in the example to be using the PHI, performing a services on behalf of the hospital. So when you're looking at what can be done between a HIC and an agent with respect to PHI, that's the use context. It's not a disclosure. So we'll look at some examples later on, but from a terminology perspective, that's an important point to look at. Let's go now to purposes, information purposes. So we've got in the uses and disclosures, we've got discretionary uses and disclosures, and these may also be called permitted uses and disclosures in certain cases. So these are, for example, a disclosure of personal health information that a HIC may do. They don't have to. There's no obligation. They can exercise their discretion to disclose or not disclose. Whereas mandatory disclosures are activities that a HIC must engage in with respect to the PHI, and the legislation will say shall. There's a little bit of a wrinkle here, and sort of only legal drafters could sort of figure this one out. And that is with respect to discretionary disclosures that may not be actually discretionary, in the sense that the PHIPAA legislation may say, may disclose in accordance with the requirements of other laws. I'm just paraphrasing here. So if you look to the other law, other legislation, And a really good example is the Health Protection and Promotion Act. That legislation has mandatory disclosure requirements. So, for example, we know that there's mandatory communicable disease reporting, okay, in the swine flu example that we're having now. So there may be a mandatory obligation of physicians to report to public health units on individuals and cases of swine flu that come into their office. So even though PHIPA may say may disclose, there's mandatory reporting under other legislation. So you've got to make sure you've sort of looked at the context to decide if you really have a choice as a HIC or you've got an obligation to disclose it. I just put this information purpose, the definition of research and researcher from PHIPA in here as a systematic investigation designed to develop or establish principles, facts, or generalizable knowledge or a combination of them. And it includes the development, testing, and evaluation of research. It may be that in some circumstances it's difficult to assess where the line is drawn between what is research or things that might be more review of health systems operations or sometimes QA, quality assurance activities. So, I mean, I just raised that as an issue for consideration. So we've got information, we've got the actors, we've got the information purposes, and so we've got a picture of what we're going to be looking at and the issues that arise when you consider data flows. As I mentioned before, I want to spend some time focusing on this concept, this term of identifiability, because of course, as you've heard, it's really, really important. And Deborah, as Deborah has indicated, her office gets lots of questions about when data is identifiable, when it's not, what you have to do to de-identify it, and etc. So what I thought I'd do is spend some time looking at sources, resources, what we have in Canada and in other jurisdictions that may throw some more light. It may even confuse the issue, I don't know. But basically what's out there in the legislation and some other guidance. I think the real practical challenge is the fact that there is little specific legislative guidance on what constitutes identifiable or identifying information, and conversely, what is de-identified information. So there's really a dearth of what's of helpful definitions out there. So if we look at Ontario PHIPA, as Deborah's indicated, they say information for which it is reasonably foreseeable in the circumstances that it could be utilized either alone or with other information to identify an individual. Well, I'm not exactly sure what that means, but one thing I know it does mean is that you look at circumstances. So it's contextual. So I think that gives you a little bit of help. The Alberta Health Information Act says the subject of the information can be readily ascertained from the information. Well, I don't know about you. I'm not sure that's helpful. If people think it is, that's good. Saskatchewan, the Health Information Protection Act, information that may reasonably be expected to identify an individual. Manitoba says information that, when combined with other information available to the holder. So I think maybe that phrase, available to the holder, is an indication of one factor that you may want to look at in the contextual circumstances. permits individuals to be identified. I want to speak very briefly. Are any of you familiar with the Gordon case? Well, to make a very long story short, in that case, the issue again was whether information could be identified if it was disclosed, and this was pursuant to a federal request for access to information under the Federal Access to Information Act. And the federal commissioner got involved in the case with respect to providing some guidance or assistance to the judge on how one would interpret personal information from the perspective of whether or not it was identifiable or not. And what was decided in that case, it was this phrase: a serious possibility that an individual could be identified through the use of that information alone or in combination with other available information. I don't know what a serious possibility is. The federal commissioner has indicated that that's sort of the test or the standard that she will apply under PIPEDA, the Federal Private Sector Privacy Law, as well. I mean, there are people that think that that is sort of a lower standard for identifiability, which means that information that some people think may be de-identified based on the Ontario definition, you know, according to this, would be treated as identifiable information. I, quite frankly, have some issues with that case and the decision and everything. Yeah.
I had a question. So as I speak to people in federal departments, more and more of them are trying to apply the serious possibility test. And I don't understand how that's clarifying the situation compared to what was there before. It is in legal terms or the legal world, is there a meaning to serious possibility? Are there precedents for interpreting what that means? Or is it ambiguous to reality?
No, and that's a very good question, because if I recall correctly, in the Gordon decision, I think there was a reference to precedents with respect to answer your question, what the meaning of serious possibility is. I would have to look at that, but I believe that is the case. And I think it's on the basis of those precedents that people interpreted serious possibility as a lower standard for identifiability than reasonably foreseeable in the circumstances, for example, the Ontario standard. So I'll get back to you on that. Deborah, do you have anything? Yeah. No, I just saw you sort of react when Khaled said that some people within federal departments were...
I think that means like any possibility.
Well, I mean, yeah. John?
I just for clarification, I mean, and maybe Khaled will go into this, but when you talk about an individual, are you talking about, say there's 100 records in a file that are supposedly de-identified? When you say an individual, are you referring to the possibility that any one of those might be identified, or whether my record, which is one of those 100, will be the one that's identified? And those are two distinct cases.
Absolutely. And one of the challenges in the Gordon case is that it was a database. And my reading of the case is, according to this test as it was applied, is that if there is a serious possibility that any one record in the database could be identified, then that whole database becomes identifiable from the way you're supposed to treat it.
I wouldn't call that a low bar then, especially if it's a large database.
No, it's a very low bar, because what it does is you're having a test for one record taint, sorry?
You're just using the wrong.
Oh, okay, taint or whatever, the entire database, but yeah.
It makes everything identifiable.
Exactly.
Basically.
Yes, exactly.
It can
That,
never be a de-identified.
that's right. We are on the same page, see? I guess we should have included those as terms that we were supposed to go through, right, to make sure we're on the same page.
That word has a huge impact on what we do. I mean, what it said is that releasing at the provincial level was possibly to identify, even at national level, there's a risk. So we're not using the information for public benefit.
I think, okay, and this is my, I guess, personal professional opinion, okay, and as Khaled knows, I did quite a detailed analysis of parts of the Gordon case. I think for many reasons, it's a very poor decision in law. I think the so-called evidence that was there by the, quote, experts that Health Canada presented in the affidavits to the court with respect to the risk of identifiability. I think that expert evidence is questionable. I think the way the court applied it is questionable. I think from a legal reasoning perspective, there are some flaws in the decision. Unfortunately, regardless of that, you know, the media applicant did not appeal the case. And, you know, initially it was, okay, the federal commissioner said she's going to apply it to PIPEDA, so that was one place. And now it's sort of migrating, as Khaled has indicated, through federal departments. And I agree with you. I think it's really problematic. And it's unfortunate. And I don't know what the answer is with respect to remedying the situation. But I would say, with respect to your point, I think one can make the argument that regardless of the level, like that, I can't remember, the database there was at the provincial level, or, yeah. I mean, I don't think that you necessarily have to say that because the finding in this case was that a provincial level database was identifiable, that means that any provincial level database is identifiable. I mean, I think that's taking the decision in this case way too broadly, because the concept of identifiability is always case specific with respect to the data and the attributes and everything that you've got in front of you. So, I mean, I would not extend the application of Gordon to any provincial level database at all. I mean, regardless of, like I said, what I think are the flaws in the case, I certainly wouldn't even do that, no. I mean, every case has to be examined on its own merits. Because if you look at Gordon and you look at the affidavits in that case, you know, they entailed, you know, statistical analyses based on the attributes and the data elements in those databases that were at issue. So, you know, as I say, I think they're always case specific. Anybody else want to add anything to that? It's, I think it's kind of interesting that, you know, when the case first went up to the court, concern was voiced. Like I heard, you know, people commented, and they commented on the approach that the federal commissioner was taking in her brief, and that it could be very problematic were the court to agree with her and apply this, problematic for researchers and a lot of other individuals. But for whatever reasons, the case proceeded with no other interveners. So, other Canadian, quote, guidance, and this is the small cell issue that Deborah referred to that I was going to speak a little bit about. And this is the Ontario Ministry of Health and Long-Term Care. It's a very old corporate policy that they have, and I believe it's from it's 1984. And as far as I know, because I received the actual formal document from somebody at the ministry not too long ago, it hasn't been updated since. So it's called the Small Cell Count and Residual Disclosure of Personal Information. And it says, when the processing of anonymous personal health information yields tabulations of less than 5, in which a possibility exists that an individual could be identified, such information will only be released to the agency head or consultant researchers and will not be included in any statistical report. And then it goes on to say what you should do. Should cell counts of less than 5 appear, the person must either suppress the cells or combine them, aggregate them up with another grouping to form a cell count of 5 or greater. From my perspective, and I worked in the Ministry of Health, and this was supposedly the policy, I didn't think this was really helpful. And I think, to get back to the point that was raised earlier, it's both over and under inclusive, okay? And by that I mean it's over inclusive in that it captures data in which, like, to use the Ontario language of reasonable possibility of identification, just doesn't exist. So for example, if you take a national database and you're looking at a cell count of individuals that, I don't know, have red hair. I mean, we know here in Ontario, Deborah and I would be there, but, I mean, even though the count may be 4 on a national level, I mean, is it really going to be possible to identify anybody on that basis if we're looking at the entirety of Canada? And if you just literally apply this policy, it's going to say you've got to roll up those cells or suppress them. So by that's what I mean by over-inclusive. By under-inclusive, I mean that there may be situations where the cell count is greater than 5. So say we, again, I don't know, it's a situation where the count is a very, very rare disease that has been publicized or whatever, that only 7 people in Canada or in the province of Ontario have that disease. It may well be that those people are identifiable, even though the count is greater than 7. And so I say the policy is under-inclusive in that just strict literal application of it would not require suppression of cells, even though there may well be that possibility of identification of those individuals. Comments? Anything? No? Yes?
Yeah, this is both a question and a comment with respect to the NOHLPC policy. I work for eHealth Ontario, I'm senior analyst in privacy there, and one of the things I did as part of my work was a study of the IPC decisions with respect to this policy. And I found consistently the IPC commissioners saying the policy isn't good enough for you to say to us, we're not releasing the information. And almost invariably, the information was released in spite of the policy.
Yes.
So I'm wondering how much teeth this policy has.
Well, what happens, and I wrote some of those decisions when I was at the IPC, saying, give me evidence, don't show me the policy, okay? I agree with you that that's basically, I mean, the commissioner's office sort of looks at the policy and then goes beyond that and says to the ministry, provide the evidence based on the particular information to which access is being sought to meet that identifiable criteria that you're using as your reason for not disclosing it. So whether or not at the end of the day it has teeth when it comes to the commissioner's office, I agree with you, it may well not have. But the issue is that when the ministry uses it internally, okay, to make decisions on whether information is going to be disclosed or not, all right, you've got a couple of problems. So if it's an access request, okay, for certain information, and the ministry's explanation is the small cell count applies, there are 4 in these cells, so it's identifiable, so you can't have it, that means, you know, the requester has to go to an appeal and get the commissioner's office to look at it. So that's on the access side. But if you're looking, for example, on the sort of the privacy research side, it's even more problematic, because what it means is that if there's a request for access to information for research purposes, the ministry is going to follow the policy and they're going to collapse the cells if they're making the argument that there's only 4 in there. So what that does is it really, you know, in a negative way affects the quality or the granularity of the data available for research. So, and the interesting thing, don't forget, is that if you read the policy, we're not talking about identifiable data here. We're talking about anonymous PHI. So already you're looking at information to which, in which there are no identifiers. Okay, so this is the next level down, so to speak, of removing information from that realm of identifiability. So I look at the policy as sort of having those potential impacts. There may be more. Any comments? No? Questions? Yeah.
I was just going to point out that I agree with you that it's problematic because it doesn't cover larger cases where there could be identifiability. But I think as written, appropriately applied, there is that statement that says in which a possibility exists that an individual could be identified. I mean, if you're looking at the fact that the information is, you know, 4 cases in Canada, you have the opportunity within this policy to say, yeah, I'm still disclosing it. Is the problem that they are just looking at the, you know, under 5, over 5 without applying that?
Yeah. I mean, as I said, they apply it sort of with, it's like an automatic rule of thumb, you know, based on the count without the could be identified. And I think that's the way that the IPC decisions have gone. They've said, okay, you've got this policy, provide the evidence that an individual could be identified. So let's look at the policy as a whole, the way it's written. I'm going to spend a moment looking at other jurisdictions and how they've dealt with this issue, because, you know, we can always learn from what's happening in other countries and how they've dealt with legislation. Are any of you familiar with HIPAA, the U.S. legislation? Okay. In the U.S., there's what they call the HIPAA privacy rule. And the statement from there is health information that does not identify an individual and with respect to which there is no reasonable basis to believe that the information can be used to identify an individual is not individually identifying health information. So what they've done in the U.S. is they've put a little bit of explanation or assistance, so to speak, in the legislation itself with respect to flushing out the no reasonable basis. And they've taken, there's 2 approaches. One that's called the Sophisticated Statistical Entity, or an SSE. And these folks, experts, experienced individuals, they apply a statistical assessment to the information, and they determine that the risk is very small, that the information could be used alone or in combination with other reasonably available information by an anticipated recipient to identify an individual who's the subject of the information. And you'll see, I think, that this SSE approach does have a relationship to Khaled's tool and everything with respect to de-identification. So there's that link there. The other approach in the U.S. is what they call the safe harbor. Basically, it's the removal from a record of 18 data attributes, and they're fixed data attributes. So I think the safe harbor approach suffers from the same shortcomings as the ministry small cell policy, in that it can be both over and under inclusive within any particular data set. And the other shortcoming with respect to the SSE is that unfortunately there are no standards for what constitutes a sophisticated statistical entity. You know, what type of expertise, what kind of experience an individual needs to have, or an organization needs to have, before it can qualify as this. So I know there's some work being done in the US on this, but that's one of the challenges. And the final jurisdiction that I want to look at with respect to identifiability is the European Union. And I'm doing this for a particular reason, which we'll see in a minute. Very often, I think, and those of you who are familiar with any of the what they call data protection legislation in the EU, it's generally considered to be, I don't know, quite restrictive, drafted from perhaps a privacy fundamentalist point of view. But I do think it has some value for a discussion today. And in the European Union directive, the definition reads, personal data shall mean any information relating to an individual or identifiable natural person. So then, an identifiable person is one who can be identified directly or indirectly, in particular by reference to an identification number or to one or more factors specific to their physical, physiological, etc. identity. And then the, I guess, assistance for determining identifiability is provided at one level in what they call recital 26. And that's basically, account should be taken of all the means likely reasonably to be used by the controller or by any other person. So in a controller, is our world just analogize that to a HIC? And you'll hear the term processor coming up, just analogize that to an agent. Okay?
So Anita, it's not just limited to the controller though, right? It's also any other person?
Yes, 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 yes. Okay, by the controller or by any other person. Okay, so we've got the controller, so imagine that in our world is the HIC. Any other person may be an agent, because they'll speak to the processor bit on the next slide, or anybody else. Okay?
So you're not just considering the specific circumstances?
Well, we are because of what the working party says later. Okay? No, and please ask the question, because it's a good one, about how far you have to speculate with respect to who may be out there in the world that could re-identify it. Yeah?
Because I have clients that are research institutions who, as part of their mandate, are publishing record level, de-identified record level data. So the potential recipient is essentially anybody who has access to the web.
Yes.
So
Yes.
lowers the bar even further.
I'm not going there. You notice I didn't touch that one. Okay, so in the European, there's this working party. I'm not sure that it's important to know who these folks are, but in any event, they're an independent advisory body on data protection and privacy. But they published in 2007 an opinion on the concept of personal data. And what I found interesting and potentially very useful was in that paper, they deal with this. They say the criterion of all the means likely reasonably to be used either by the controller or by any other person should in particular take into account all the factors at stake. And then they list all of these factors. Okay, so the cost of conducting identification, the intended purpose, the way processing is structured. So that basically means what's going to be done to the data. The advantage expected by the controller. So, and I would say in that point, that fourth bullet point, the advantage expected by the controller, the processor, or any other person. So is there a benefit to be gained by re-identification of the data? You know, what are the privacy interests at stake if individuals were to be identified? You know, the organizational risks. So technical failures. So if you've got an entity that's receiving de-identified data, do they have the technology framework and everything to ensure that the data is maintained in de-identified format? The state of technology now, I know we can't have a crystal ball, but with respect to that period in which the data is going to be used, the development of technology with respect to re-identification. And again, like the controls to manage any future developments. So this is the first and actually sort of the only real drill down that I've seen of specific, you know, they say take all the factors into consideration and look at the context. This is the only reference that I've seen that speaks to, you know, specific factors that you may want to consider. And you'll see how these factors have been incorporated, where appropriate, into the framework that CALAD has developed. So, you know, many of these bits and pieces that we're looking at from other jurisdictions do have relevance and applicability in our world to sort of help us fill in what I've, you know, sort of demonstrated is the dearth of guidance or legislative direction in Canada with respect to what's de-identified information. So is that sort of, anybody have any comments about identifiability? No? We know it's an issue, right? Right? A big issue. Is that the understatement of the morning? Okay.
Well, just one. Under the recipient rule, if the HIC provides to a recipient on two separate occasions de-identified data sets, what are the obligations on the recipient to make sure that there's no linkage, or on the HIC provides those two sets, that there's no linkage between those data sets to re-identify individuals based on that linkage?
Well, okay, that raises a very good question because, as we'll see, okay, in that case, because the data is de-identified, right, there's no obligation to follow any of the rules in the legislation. So, for example, a HIC providing to a recipient doesn't have to enter into an agreement, right? It's de-identified data. And you've hit the nail on the head with respect to one of the risk points dealing with de-identified data. And I'm going to speak to this because obviously I think the objective from the HIC's perspective is to make sure that that data stays in de-identified format. So the HIC wants to ensure that the recipient does not link those two databases to either re-identify or increase the possibility of identification. And so to me, that's a really good example of what we're going to speak to later on with respect to, you know, de-identified data and risks and mitigation strategies. Okay. I'm going to go back, and I don't want us to sound like a broken record because Deborah dealt with this before. But what I'm going to do in this section, building up our scenario, is I'm not going to speak to all the fair information practices, but just a couple of the privacy principles that I think are important in the context of disclosure for secondary uses. And Deborah has spoken of these as initial considerations, and I think it's really worthwhile to review them again. And that's the concept of other information, that a HIC shall not collect, use, or disclose PHI if other information will serve the purpose of the collection, use, or disclosure. And I think, you know, both of these principles are probably not given the attention that they deserve, because, using Deborah's example, if the other information is de-identified information, then the principle, the legislation in this case, requires that the information be disclosed by the HIC in de-identified form. And it may be easier to disclose the entire record database in identifiable format. It may be cheaper, it may take less time, but the reality is that this is a really important obligation. But not only is it an obligation, what we will see, and if you think about it, it makes perfect sense, it substantially limits the risk factors. Okay, so yes, it may take more time. Yes, you may have to put a little bit of cost up front into reconfiguring the database to strip the identifiers, apply COLED's tool for de-identification. But if you think of, and we've got lots of examples, and I'm not going to go into them, but if you think of the potential consequences with respect to data breaches, if you disclose just because it's easier, faster, cheaper in identifiable form, I think from a cost-benefit analysis, it's going to be pretty self-evident that it's worth it to take the time up front to de-identify it and apply this principle. I think the other thing to recognize as well is, don't forget that if you do disclose it in identifiable form, you've got to make sure, you've got to do your due diligence that the entity to which you're disclosing it has the appropriate security in place, you know, to minimize the risks of loss and breach and that kind of thing. So that's another issue. The other thing is, if you're making it available to one of your agents, okay, and de-identified information would suffice, and you don't do that, you as the HIC still have control of it and are still responsible. So if something happens and there is a data breach that occurs when the data is physically, for example, in the custody of the agent, but you're still in control, it is your responsibility still. So there are many, many reasons why this principle is important, and it should be observed perhaps more than it currently is in practice. And the other principle is the extent of information, and it's related to. And that's basically that a HIC shall not collect, use, or disclose more PHI than is reasonably necessary to meet the purpose. So this is the second sort of question. If you determine that you've thought about the first consideration and you've come to the conclusion that the purpose necessitates the disclosure of identifiable information, then you come to the second question and you say, okay, but really, how much is really reasonably necessary for the particular purpose? Do we have to give all the records in the database, or really are they just looking to see what's happening with respect to the males or the females or people of certain age? And again, it may take time up front to, you know, configure the database to those records that are the ones reasonably necessary, but it can save a lot of grief at the end of the day. I just want to clarify some things about consent, and Deborah's certainly spoken about this in a lot of detail. But remember that consent's a relevant consideration if the data is not de-identified, encrypted, or otherwise made anonymous, and there's no legislative exception for the use or disclosure of the information in identifiable form. And we're going to go through the exceptions. And as Deborah noted, in the case of PHI, if consent's required, you're going to express consent is what's going to be necessary, and opt-out for this is just not going to work. Another principle that's important in the context, again, these are principles that in the secondary use and disclosure world, in my view, are important. Sure, there's fair information practices as a whole, but in the secondary use disclosure scenario, these are the important ones, I think. This is back to the situation that I mentioned just previously. HICs are responsible for PHI under their custody or control in the accountability principle. So when PHI is accessed by one of your agents, the HIC remains accountable in the event of a data breach. Okay, the HIC is still responsible if something happens to the data in the hands of the agent. And actually, this is kind of interesting because the way PHIPAA reads now, I think it can be interpreted that the commissioner doesn't have the authority to make an order against an agent only. So say, for example, there's a scenario where HICS provided PHI to an agent, and they've done an agreement, and the HIC has crossed T's, dotted I's, and everything. There's a data breach because of something that happens at the agent side of it. There's a complaint, somebody investigates or whatever. At the moment, despite the fact that, number one, the agent was actually at fault for causing the breach, and number two, it may have even been that the breach resulted because the agent didn't follow the rules in the contract with respect to the data. I think the commissioner's view is that she still has to make an order against the custodian, the HIC as well. And I think that in the submission she made for the review of PHIPAA, she was looking to clear authority to just make an order against the agent. And I don't think that change is going to be made. So that means that you as the HIC may have done everything in your power with respect to providing the PHI to the agent, but if there is a problem, again, you may have an order against you or a complaint made to the commissioner about your practices. So again, that's another reason to give serious consideration to the other information and the data minimization principles. And I believe the final principle before we get into secondary uses that I want to talk about is security. There are no prescribed standards in Canadian law. Some of the concerns are in the electronic health information world. Due diligence on the part of a HIC before PHI is accessed by or disclosed to another entity. So, and again, this is important because, you know, even in the research context, of course, if the REB approval has been given for the researcher to access identifiable information, you know, there are security obligations. Contractual requirements, so again, agreements can have the security requirements. And again, I'm going to point this out, and we're going to pick this up later on, but the risks of re-identification. So now, I guess, that we're sort of halfway through and we've laid the groundwork, I'm going to speak about secondary uses and examples and that kind of thing. I have until 15 minutes, that's it? Okay, so, all right. We're all on the same page. Secondary uses, this is just a review of the terminology. The policy rationale, Deborah has gone into in detail. Some legislation calls them secondary and some calls them permitted uses. The next few slides, and I'm certainly not going to get into them in any detail, but what I did was I reviewed the health information privacy legislation across the country. So we've got Ontario, Newfoundland, the HIA in Alberta, Saskatchewan, I guess we have Manitoba here too. And what I've done, even though it doesn't really fit into neat little boxes, is sort of group the exceptions under the purpose of the disclosure. So remember, these are secondary uses. They don't, under the legislation, require patient consent. And it was just to give you really a flavor of, I guess, the policy rationale and the policy justification that's been accepted in Canadian legislation to allow these disclosures without consent. So you'll see for health or other programs related to risks to the individual or other people, individuals in care and custody, for example, incarcerated. And what you'll see in the other two columns, you'll see mandatory or discretionary. That relates to what we talked about before. Whether there were any restrictions on the recipient and the legislative references. So there's a number of these: disclosure for proceedings, successors of custodians, other acts, and all the legislation has research provisions which are different across the board. Okay, planning and management of the health system, analysis of the health system. And so that sets the stage for all kinds of examples. So what I want to do is drill down a little bit more and sort of walk through the questions in terms of an analysis that we have to ask ourselves in particular case scenarios for secondary use of PHI. So this situation, a health information custodian is approached by some entity for access to clinical PHI to use it for one of the secondary purposes. So what do we have to think about? Is disclosure required? So must the HIC provide access, or does it have the discretion to do so? Even if the HIC must provide access, are there any conditions that have to be met? And if the provision is discretionary, has the HIC considered relevant factors in exercising the discretion? And very often, organizations will have their own policies and procedures on how to deal with these things. So for example, when there's a disclosure for law enforcement purposes, you know, your institution may have a policy that says, you know, the request must come in from the police chief, and it must be on letterhead, and there must be an affidavit explaining why it's necessary for an investigation, that kind of thing. So the legislation sort of sets out the bare bones that are sort of supplemented within every organization in these disclosure situations. Back to those two key principles: is the information required in identifiable form? Will other information suffice? And if other information will suffice, think about the method of de-identification or anonymization that's most appropriate given the purpose of the data. And Khaled's done a lot of writing on this particular thing. And if identifiable information is required, what's the extent to satisfy the secondary purpose? So basically, manipulate the data as required to prepare only that which is reasonably necessary. Who are the actors in this scenario? Okay, the relationship between the HIC and the entity seeking access. Is the entity accessing it to perform a service for the HIC? So that means they're an agent. Is the entity another HIC in the legislation? Or does the entity fall outside the scope of the legislation? The information flow. So if the information is going to an agent, as I said before, that's going to be a use. And if it's not, if it's going to another HIC or a recipient, it's going to be a disclosure. And then you have to look at the purposes. So you have to make sure that the secondary purpose for which access is being requested is one, and Deborah noted that, and you'll see the list, that is permitted in the legislation that the HIC can disclose without consent. And again, there may be conditions in the legislation that are attached to that. And of course, if it's outside the permitted secondary disclosures without consent, consent is going to be required. And accountability, and this is something that I find is really interesting and sort of leaves open a huge risk in PHIPAA, and that is when information is being provided to an agent, there's no legal requirement for the HIC and their agent to enter into an agreement. I don't know of any entities that would just provide the data without an agreement that sets out all kinds of things like the contract, the responsibilities of the agent, as well as all the requirements that the agent has to follow with respect to the PHI, some of which are in the legislation, using them only for the HIC's purpose, and some of which may be other requirements that the HIC imposes. But from where I sit, it's absolutely critical to have those agreements. So this is just sort of a little table that sets out, we have a data flow scenario. A HIC provides access to data for a non-research purpose to, and you can see, if it's an agent, they may be internal or external. It may be PHI or de-identified PHI, and the type of disclosure is not important, mandatory or discretionary. And you'll see in this case, what I've done is I've identified by a single asterisk parts of the scenarios where there's opportunities for risk management. So where there's a single asterisk, the issue is de-identifying the PHI to manage risk. And where there's a double asterisk, and you'll see that's all the way along, for the agreement. An agreement is a critical way, in my view, in which you can manage risk, and certainly that of the HIC that's disclosing the information. This is the data flow scenario where a HIC provides access for a research purpose. Regardless of the characterization of the researcher and its relationship to the HIC, the research rules in PHIPAA always require REB approval and a research plan. An agreement, a research agreement's always required between the HIC and the researcher when the researcher is external to the health information custodian. I think there is a question under PHIPAA in the scenario in which the researcher is internal, okay, to the HIC, and they want to access data for a research purpose. So say you have an individual working within a hospital, and they want to use some of the hospital clinical data for a research purpose. And it will be a use if the research that's being performed is on behalf of the hospital itself, And in that case, the researcher is sort of considered to be part of the HIC, so an agreement is not required. But if the researcher is using that data for their own independent research purposes, I would say that even though they are operating within the hospital themselves, the hospital should require a research agreement with that individual, in addition to the REB approval and the plan requirement. Remember, disclosure of PHI for research purposes is always discretionary. I wanted to spend some time, in the time I have left, dealing with disclosures for public health purposes. And I think they're important and they're relevant in the swine flu scenario. I'm going to look at these provisions from PHIPA and also go through a diagram of data flows here. And PHIPA allows a custodian to disclose PHI to the medical officer of health within the meaning of the HPPA, that's the Health Protection and Promotion Act, if disclosure is made for the purpose of that act, to the Ontario agency, which we're not going to talk about, and to the Public Health Authority, similar to our medical officers of health in another province or territory, etc., if the purposes is similar to the HPPI. I think what's really important to remember, because some people say, oh, the provisions are big enough to drive a truck through, there were amendments to this as a result of both the Walkerton and SARS inquiries in Ontario. And in those scenarios, many people say that privacy legislation was a barrier to the disclosure and dissemination of data as quickly and to all the players that required it to contain the outbreaks. So as a result, these amendments were made, and they are pretty broad. As you can see, you've got to look at the purposes of the HPPA because they're referred to in PHIPA, and the purposes are set out here. Organization, delivery of public health programs and services, prevention of the spread of disease, and the promotion and protection of the health of Ontario. And it's kind of interesting that one of the mandatory health programs in the HPPA is collection and analysis of epidemiological data. And again, you'll see, related to the point that I made before, that again the HPPA requires certain mandatory reporting with respect to diseases identified in the HPPA as communicable or under different standards. So again, just setting this out in a little different format, hopefully to make it easier to understand. But the notes are important here, that when a HIC is disclosing for public health purposes, they may disclose identifiable information without consent. They should think about the other general principles, limitation, de-identification, and legally, no agreements whatever are required here. So let's go through the data flow, and we're going to use an example that Khaled provided to me, and I guess it's a real-life example. So you can read it for a moment, excuse me, while I get a little more water. Can I have some extra minutes?
Yeah, sure.
Okay.
Our big copy's going to be on there.
Okay, perfect. Thank you. Okay. So Khaled gave me this example and said, all right, how is this supposed to work? So as we walk through this, hopefully this is sort of building on all the other information and the concepts and the terms that we've gone through to date. Okay, so here we have a hospital. Okay, they're a health information custodian under PHIPA. Okay, they're providing PHI to a public health authority. Okay, so the public health authority is also a health information custodian. All right, so let's look at the nature of that transaction. It's a disclosure, and it's permitted, the hospital is permitted to disclose the information in identifiable form for the HPPA purposes. It's discretionary. Think about the general principles of other information, minimum necessary, and no agreement is required. So, any questions about this? This seems pretty straightforward at this stage. Okay. And then the next scenario, the next fact thing, was the public health authority that had received the information initially to conduct its syndromic surveillance program wants to use the information that it received for that purpose for research purposes, right? So what we have here, the public health authority, and the arrow goes both ways because it basically within the entity, and this is going to be a use. So I guess the question that a lot of people might initially have is, we have the hospital that disclosed the information initially to the public health authority for one purpose, i.e. that public health surveillance purpose. And now we have the public health authority wanting to use it for effectively an independent purpose of its own. And the question is, does the legislation allow it? And the answer is yes. And so then the question is, does the public health authority have to enter into a research agreement with the hospital? Okay, and this could be assuming that the authority had the data, was using it for surveillance purposes for a couple of years, and then they decide, oh, we want to do some research on this. And I guess in that scenario, what I would say is no, they don't. Certainly within the public health authority itself, they have to prepare a research plan, and they have to get REB approval, and they get that approval from their REB at the public health authority. They don't have to go back to the hospital to get it. And no research agreement is required. On the other hand, if at the time the information is being disclosed to the public health authority by the hospital, and the public health authority sort of contemplates that, you know, in addition to the surveillance, they may be doing some research of their own, then I would say in that situation, there should be, the research requirements should be followed vis-a-vis getting approval from the hospital REB and a research agreement being entered into between the hospital and the public health authority, and it's a matter of timing. Yeah?
One small thing. When I do this kind of analysis on the receiving end, just because the disclosure is allowed on the one HIC, you also have to account for the collection.
Yes.
What is the authority for collection, especially because although public health authorities are HICs, they're not HICs that are allowed to depend on implied consent, so they have to have a
right. And what I should have indicated at the beginning of this scenario is that PHIPAA allows for the collection without consent by all the players in this scenario. I didn't get into the collection, but it assumes, because we know in this case, that all the entities that are receiving PHI from somebody else do have the authority to collect it. Okay, but that is a good point, because when you're doing this analysis, you do have to look at both ends. Is there authority to disclose? Is there authority to collect? Okay, and I just didn't put it in the picture here. Okay, so Anybody have any questions about my comments about the Public Health Authority using it for research purposes? No? Okay. So then we have the scenario that a university approaches the Public Health Authority and the university wants to do some research on that same data. So we have the Public Health Authority and the PHI going to the university. And in this situation, it's a disclosure. And it is permitted, again, under PHIPA, under the regulations. The sort of onward disclosure, if you will, is permitted to another researcher. A research plan and REB approval are required, as is a research agreement. So in this case, I would suggest that we're going to have a research agreement entered into between the Public Health Authority and the university, and the plan and REB approval are going to have to come from those entities within the Public Health Authority. But one of the interesting things that I think this scenario demonstrates about PHIPA is that information in identifiable form may be disclosed when there is authority without consent for certain secondary purposes. As John indicated, you've got another HIC, for example, that's got the authority to receive it, and then that HIC has the ability under the Act, under PHIPA, to use that information for other purposes for which HICs may use information. So that's an important thing to remember. Any comments?
I just don't understand why you say the REP at the Public Health Authority has to approve the protocol.
Well, I would say because in this case, the university wants to access, okay, the university wants to access the information that's currently in the custody of the Public Health Authority. So, I mean, in my view, generally, isn't it the entity that will be disclosing the information whose REB has to give approval for disclosure?
The receiving
The
organization, like if you're disclosing to ISIS or something like that for research purposes, it's ISIS's REP that approves that, and you get the protocol.
And you get the protocol as the authorization to disclose. All right, so
Could be anybody's REP.
well, that's the point, right? I mean, yes, and thank you for raising that, because it doesn't say, the legislation actually doesn't say which REB has to approve, right? So that's a very good point.
Yeah, but when you're disclosing, it doesn't have to be your REP. I just want to make that.
Can I just ask a question though? You're talking about identifiable data.
Yeah.
So, if you're saying that it doesn't have to be the public health REP, what university REP is saying it's not being disclosed? I'm questioning why it wouldn't be the public health authorities, because they've received it from an organization and it's still identifiable.
They could do it if they wanted for due diligence purposes, but they're not required
They're not
to do
required
it.
to.
Yeah.
Yeah.
But also, I think the important point here is, one important point is that you don't have to go back to the hospital's R&D to get permission to use their data in a research project by a university which the hospital may have not anticipated in the outset.
Yeah, yeah,
That's my concern.
yeah. And as I said, the Act, the legislation, allows this flow through as long as certain conditions are met at certain points. So is that clear, helpful? Yes, no? Let's just see. So again, I've just set out in sort of tabular form the different elements. So the first was the hospital authority disclosure, public health purposes, you know, risks of unauthorized use, disclosure, etc. So for risk mitigation, if it's possible, de-identify, anonymize, and provide the minimum necessary. It may not be possible, but your mind should be turned to that. Within the Public Health Authority, the use for research purposes, again, there's going to be REB approval and a research plan, and then the final leg of the data flow from the Public Health Authority to the university itself, requiring the plan, the research agreement, and REB approval from either the university or the Public Health Authority. Okay?
So a question to your earlier point on if an order was set, that it would not only be the agents, but that it would be involved. So if there was a breach at the final end of this pass, the university breaches, who's getting in trouble?
Well, don't forget what I talked about was the agent situation. Okay, so here, if you look at the hospital and the university, there's no relationship between the two of them. And so, say, for example, I mean, there was a breach at the university end, and there was, as there would be required to be, the research agreement between the Public Health Authority and the university. I mean, it's going to be the university because that's a disclosure between the Public Health Authority and the university for research purposes. So that's going to sit on the university's head in that particular case. Whenever there are disclosures, it sits on the recipient's end if there is a problem. But again, there's legal problems and there's public relations problems and everything like that. So it's well in the interest, in many cases, of the disclosing entity to sort of have an agreement or cover its tracks or whatever to make sure that in the event there is a problem, they've done everything and it just sits at the recipient's side. Okay? Explain.
Do the mandatory breach notification requirements apply to recipients who are not based?
In accordance with the research agreement, the university would have to notify
Exactly.
the Public Health Authority that they're in breach of that agreement.
If that was
And
part
then
of
the
it.
Public Health, well, they would have to, it's part of the agreement.
Yeah, yeah.
then
And
the
it's
Public Health
required in,
Authority could potentially go back to the hospital and say, look, you gave us this data, we give it to research, it was breached, and then the hospital would have to notify the individual.
but there are the act, just to pick up,
Out of that flow, though, why would it, if the Public Health Authority is a hit with all of those same responsibilities, if they're the aggregator of data and they own that relation, why would they not be?
They would have an obligation to notify, but they wouldn't have a direct relationship with the individual, so I don't think they would notify. I think the hospital would notify.
I think the hospital would notify too.
If I were a hospital privacy officer, I would be in panic at this stage and not be disclosing anything to anybody.
And
So I don't see the logic of this. I don't. Speaking as someone who does practice as opposed to, interpreting the IAPP stuff, but speaking as someone, I've worked for hospitals, I also now work for an agency which is at the center of almost every disclosure, electronic disclosure in the province. And I'm looking for scenarios in which we're not going to get tainted in such a circumstance. Can't not see it. Okay, so if it's disclosed to the Public Health Authority, Public Health Authority has a breach. It's disclosed, it's theirs, it's in their hands. It's not an inferred or a disclosure for the purposes of health care by implied consent. It's a disclosure, it's going. So would the Public Health Authority not retain the responsibility?
but they do. They do.
But the letter.
No, we're talking about,
Comes from the hospital.
no, we're talking about two different scenarios where the breach may occur. So if we go through the first scenario, okay, hospital, the PHI goes to the Public Health Authority for public health purposes, no agreement, no nothing authorized in the legislation. If there is a breach at this stage, okay, up here, then the Public Health Authority is responsible for notifying. However, what Deborah was talking about was it may be that they don't have a direct relationship with the individuals, so that they might practically want to work with the hospital to work out some kind of notification regime. I would imagine your office, I would imagine your office would get involved with respect to how to implement that, but the obligation is here. But to your point about practical realities, that's why we were talking about the hospital, okay? If, on the other hand, is that clear?
Yes.
Is that okay? Okay. So then, if on the other hand, the breach occurs down here at the university side, okay, that means, don't forget, there's a disclosure, but in this case, there's going to be a research agreement. So, and the legislation has provisions that require notification in the event of a breach. So if there is a breach, then the university will have breached the research agreement, okay? And they will have had to notify the public health authority pursuant. Welcome back. I hope you are refreshed from the coffee break. Before I move on, I just want to pick up on something that we were looking at before the break, and that was if there was a breach at the university end of the equation, the researcher end, where was the obligation to notify? And Deborah referred me to a section of PHIPAA that I guess I haven't looked at very much. And it says, if the health information custodian is a researcher who has received the personal health information from another health information custodian, the researcher shall not notify the individual that the information is stolen, lost, etc., unless the custodian first obtains the individual's consent, having the researcher contact the individual and informs the researcher that the individual has given consent. Well, we were just discussing that from a practical perspective, that makes absolutely not very much sense, because what you'd have pursuant to that is the public health authority, and they may not, I mean, even be the entity that's got the direct contact with the individuals on the data list, contacting those people and asking them, do you consent to the university researcher contacting you to tell you that they've had a data breach? So, I mean, you know, you can imagine if you're a person and you'd say, what, who, where, when? So, I mean, I effectively, the notification is, you know, will sit with the authority, who may, as in the first scenario, very well go back to the hospital and consult with the commissioner's office with respect to sort of who is going to take the lead on the notification and how that protocol is going to roll out. Okay, is that all right? Apparently, the computer is still on coffee break. That's okay. Thank you. Okay, so we went through this summary table, excuse me, which basically just sort of sets out in a different format the information that was included in the diagram. And now really to sort of set up the segue into what Khaled's going to be discussing next, I'm going to very briefly touch on risk mitigation. So just a review of some of the concepts that we've looked at. So if information's not identifiable, it's not PHI, not subject to the provisions of privacy legislation. And in the Ontario world, HICS may collect, use, or disclose such information that is de-identified for any purposes standing entities. But I would suggest that certain risks remain. And those are the risk of re-identification of the data by the recipient. So assume for the moment you're a HIC, you're disclosing de-identified data, and then in the hands of, and this may be another HIC or whatever, the data becomes re-identified. So the associated consequences are going to be obligations to notify, the invasion of privacy of the affected individuals, your bad PR, embarrassment of both entities in that particular scenario, investigation likely by the privacy commissioner, potential litigation filed by affected individuals. So if we look through risk mitigation further, let's look at a few things that we may do. Okay, so data sharing agreements, and this is when legally they may not be required, but again, to minimize and mitigate risk. And having those agreements set out basically mitigating controls, which are the appropriate management of the information by the recipient. And of course, one of those things is going to be, you know, a requirement that they not do anything to attempt to re-identify the data. And something else that we may look at, like through the data sharing agreement with respect to what we're going to put in there, is the motives and capacity, or the ability and the incentive of the recipient to attempt to re-identify. So remember, this really relates to one of the factors that we looked at from the Article 29 Working Party in the UK, the ability and the incentive to attempt re-identification. And they talked about motivation, and sort of this idea captures that. An invasion of privacy, again, something that came from the Article 29 Working Party, and that's the consequences. You know, you look at the nature of the information if it were to be re-identified, and the consequences to the affected individuals in that case. So to wrap it up, just a few concluding points. All Canadian privacy legislation allows for secondary or permitted uses of personal health information without consent in certain circumstances. It's critical to understand the meaning of the terms, to define the information, the actors, data flows, and purposes. Again, I'm going to try and hammer this home, the general principles that should be considered: data minimization and de-identification. And again, while there are numerous cases where PHI may be disclosed and used without consent for secondary purposes, both the legislation and your own practices and policies may have certain conditions attached to that. And finally, even though de-identified information isn't subject to privacy legislation, the possibility of re-identification does make it prudent for health system actors to consider the use of data sharing agreements as a risk mitigation strategy when using or disclosing information in this form. That's all from me. I realized that I didn't identify myself at the beginning of the presentation, so here's the contact info at the end. I'm president of my own consulting and legal practice, and basically my area of expertise is certainly privacy, health information privacy, having spent time at the Commissioner's Office and the Ministry of Health Legal Services, and a private sector multinational involved in the health information business. So I thank you. If any questions about this, if you've got them now, or they may occur to you as we go to the next phase, please feel free to ask, and I'll be here for a bit. Yes, John?
One last question. The lockbox, can in the unlikely event that the person's concerned about secondary use, could they use the lockbox provision to prevent secondary use?
There are restrictions with respect to that. You cannot lock up your information to prevent it from being used for research, right?
You cannot lock it against uses and discussions that are permitted without consent.
Thank you. And that includes research.
Including research.
Yeah. Okay. Only for care, treatment?
Well, you could, anything where you provided consent,
Right.
you can withdraw that.
Right, right.
So you could do that.
Okay, thank you. And I'll now turn it over to